Thank you, Ni. Let me come to Honorable Acheampong. Honorable, your party says the suspension of the CJ is unconstitutional. It is absurd. And of course, they are basing this on the fact that there is an injunction application before the Supreme Court. I do not know whether an application for an injunction is same as an injunction, and whether the law permits a president exercising his constitutionally mandated duty can be injuncted.
The Supreme Court himself has given that decision.
Yeah.
What
But the party is basing its argument on the constitutionality of the suspension or otherwise of the CJ on same.
Dana, if I proffer any counsel to you this morning here, any form of explanation, the next response from my friend, the Deputy Attorney General, will be me expressing my desires. Because if you say anything contrary to his position, is your desire. But if he expresses it, that is the technicalities that we are following. That's why last week I said that we just have to be careful in dealing with matters like this. Now I come with an understanding that I've been toying with in my mind. You see, in removing someone in an office that is a high office, such as the office of the Chief Justice of the Republic of Ghana, one needs to be very careful and cautious. If care is not taken, we could suffer what people call in politics and in multi-party democracy as what we say democracy capture. Now, you look at the ingredients before you. What do I call democracy capture? Democracy capture will be referred to as a situation where a clique or a party is able to appropriate to themselves the institutions and processes as well as dividends thereof in governance. So if you look at the ingredients before us today we have the president occupying the executive. And if anything which we have studied in terms of democratic practice within the rule of law principles, which Montesquieu teaches us to be separation of powers. You have the executive arm of government, you have the legislative arm of government, and then you have the judiciary headed by the Chief Justice. So today, you have the executive presidency with an overwhelming majority. So that institution, like the presidency, is occupied by one party. The legislature is also occupied by one party. You trigger processes. You have the Council of State appointments primarily made aside those elected by the president. And so you go, and then the judiciary, which is also supposed to be an arm of government, is also changed by
an independent arm of the government.
That's another independent arm of government. And the judiciary goes through this process. Immediately, democracy capture is seen clearly before you. And for our democracy, which is still a fledgling democracy because we are not there yet, very young, we need to be very, very careful. That's why I said so. And the Constitution is so advised, the Constitution advises us that we have, in the exercise of the duty, the president must be fair, the president must be candid. If you look at Article 146, the entirety, you see, when I listen to some of the arguments, I'm not a lawyer, but the little things I learned from Parliament sitting with my brother, Nick, is that if you read an article, you don't read the article in part, you read it in whole. That is why people are moving us from, I hear some arguments that takes us away from 14610, then jumps us to 296. And then 296 will give you, because 14610 gives a discretionary power. And that is where, after 1466, the matter is in reference to the Chief Justice. That's what the Constitution says. And then the president kicking the processes and will come to 14610. Now, when it comes to 14610, then it will say it is discretionary. If it is discretionary, the governing authority of discretionary is taken from 296. That's why that argument is been coming up. But I come here as a beneficiary of this democracy and the knowledge I have gained, preaching against democracy capture. Because if you are not careful, the actions that you do, the processes, let's find out. So far, I've been listening to what has been made known to the public. I haven't seen any of the petitions myself, but it speaks to interpersonal conflicts, some travel issues. Under the circumstance, are we saying that these things trigger an impeachment? Are they high thresholds to trigger an impeachment? That is why the rules and the instruments which are being called for is very necessary here. Do they trigger an impeachment? Because definitely in an institution like we are here, and even in your establishment, people may not like the style and approach of others. But hey, we must cooperate to work together.
Isn't it therefore important that we know what is exactly in this petition and what's the threshold or requirement for such a petition to cut it before a prima facie can be established?
That is why you hear some commentators. I've heard some civil society advocates. And for instance, the chairperson to the Constitutional Review Commission has been talking about how opaque 146 looks and
entire
seems.
Process shrouded in secrecy.
It's so. So these are the things that we have to guard against democracy capture.
I like the way you are hitting this democracy capture thing, but others may argue that similar thing happened under your regime, although you had a slim majority in parliament, but you made several appointments onto the bench.
Was it the crime of the officer in charge at the time when the vacancy had occurred? In public administration, once there's a vacancy, the vacancy ought to be filled. It is not by your choice.
There's this argument that even in the instance of the CJ, she was promoted over her superiors.
You see, even if I serve you a cup of tea, somebody could say that I gave you a bad cup. But in my mind, I will be offering you the best available cup that I have. So people definitely have opinions, like I'm expressing mine.
Right.
So if you want to deliver and you want to achieve your purpose, you have to stay the course. That's why some argue that in this circumstance, the president is a conveyor belt. And if I read 146, I agree that it's a conveyor belt. That is why I raise up that argument that if we are not careful and cautious in due process, we could experience what we call democracy capture. And it's very crucial. So if I'm repeating myself, I said last week over here that we have to be fair. And it's not me saying so. The Constitution says so. So in this entire process, we need to be very, very careful because arguments are washed and abound. Clearly, democracy capture is being seen. And so we ought to be very, very careful. Now, for me, consistency is important.
Very key.
I've listened to the Deputy Attorney General. He gives all of us the impression that there is no conclusions. There is just a prima facie case to kickstart a process.
No malice aforethought.
No malice aforethought. Then I come to listen to the communication officer of the ruling party. He says the CJ's responses are confessions. And all of them are in government and speak for and on behalf of government. So I pray we are not practicing what I hate to hear, an animal farm practice of communication. The two gentlemen on my left appreciate it better than I do. So consistency is key in this process. And we have to, because the democracy we are practicing is not just for me, but for us today, posterity, and even past would also have the opportunity. You see, for the benefit of hindsight, people will sit back and say, did we get it right?
Yeah.
When we have, last week I said, in this processes we are in this fourth dispensation, fourth Republican dispensation, the most experienced person so far created by this constitution is our current president. And so every step out there, we expect the best. And that's why we are all commenting in this manner.
Very well.